Hello, everyone. So apparently there was a request for me to react to this video from D.A. Morrissey's statement on the Karen Reed case from 11 months ago. The Norfolk County District Attorney Michael Morrissey demanded that harassment of witnesses in the prosecution of Karen Reed over the death of her boyfriend, Boston police officer John O'Keefe, needs to stop. Well, I mean, I'll certainly agree with that. I mean, there's no reason to harass witnesses or literally anyone else. But I've been told that this is a bit of a hostage video. So I thought maybe we could respond to that. And I take a look at him right away. And I'm like, yeah, I kind of see why you guys are saying hostage video. I'm definitely feeling a little bit of those vibes here. Let's see what he has to say about this case.
This will be the first statement of its kind in my dozen years as Norfolk District Attorney.
Okay. The first time you've ever given a statement like this as a DA? Cool. All right. So that's neat.
Harassment of witnesses in the murder prosecution of Karen Reed is absolutely baseless. It should be an outrage to any decent person, and it needs to stop.
Okay.
Innuendo is not evidence. False narratives are not evidence.
I would tend to agree with you on those points, which is a little bit the problem, in my humble opinion. Innuendos are in fact not evidence, and false narratives are also not evidence. Lessons that your own office perhaps could take a little bit more to heart, in my humble opinion. Cool.
However, what evidence does show is that John O'Keefe never entered the home at 34 Fairview Road in Canton the night he died.
Well, the evidence is a bit ambiguous on that point, but sure, let's take it as a given.
Location data from his phone, recovered from the lawn beneath his body when he was transported to the hospital, shows that this phone did not enter that home.
Yeah, I don't know that you're going to be able to get that precise on the data on the phone, but sure, let's go with he didn't enter the house. Sure.
11 people have given statements that they did not see John O'Keefe enter the home at 34 Fairview that night. 0 people have said that they saw him enter the home. 0. No one.
Okay. I mean, not to put too fine a point on it, but obviously they could be lying, particularly if they were in any way involved in Mr. O'Keefe's death. Maybe not necessarily thrilled to admit that he was in the house. Just, okay. And also, of course, the fact that no one says it happens doesn't mean it didn't. Although, okay, pressing on. The police could have, searched the house, and people were like, could we have gotten a search warrant for the house? It's like, I actually don't know for sure, probably, but they could have asked to look around, and they didn't even ask to look around the house. They didn't even bother asking, which is great police procedure. That's nice.
Some have, without any evidence, pointed to 18-year-old Colin Albert, a nephew of the homeowner, and accused him of attacking John O'Keefe as he entered the home. But phone evidence shows O'Keefe never entered the home at all. Testimony from witnesses tell us that 18-year-old Colin Albert had left his uncle's home before John O'Keefe and Karen Reed had arrived outside the residence. There was no fight inside that home. John O'Keefe did not enter the home. Colin Albert, the young man being vilified, was not present when Reed's vehicle and John O'Keefe arrived on the street.
Okay, yeah, but those are not necessarily the same thing either. Whether or not he was present at the time that John O'Keefe arrived and whether or not he was outside at some later time are not necessarily the same thing. Okay, all right, pressing on.
This is a false narrative. Colin Albert didn't commit murder.
Okay.
Jennifer McCabe, Matthew McCabe, and Brian Albert. These people were not part of a conspiracy and certainly did not commit murder or any crime that night. They have been forthcoming with authority, providing statements, and have not engaged in any cover-up.
I don't know, man. I don't know about you. I think that some of them may have engaged in steps that seem suspiciously cover-up-esque. And I'm not necessarily sure that personally, I mean, credibility is a matter for the jury. So I guess you can disagree with me, but I'm not sure I particularly found any of these people especially credible on the stand. But, maybe that's just me. It could be just me. Maybe it's just me. All right, pressing on.
They are not suspects in any crime. They are merely witnesses in the case.
Not being suspects and not being the bad guy are not the same thing, of course. Maybe they should be suspects. Yeah.
To have them accused of murder is outrageous. To have them harassed and intimidated based on false narratives and accusations is wrong.
You keep saying false narratives and accusations. The state's narrative also not really doing fantastically, in my opinion. So I'm not sure necessarily there's necessarily any narrative that's better than the state's narrative. Although I'd like to point out that just because it's the best narrative, even if that's true, doesn't mean that the state can prove each and every element beyond a reasonable doubt, which is their obligation. This is not a competition of which narrative is best narrative. This is a question of, can you prove your case beyond a reasonable doubt as to each and every element of the charge? And the ARCA guys have some questions rooted in physics at a bare minimum. So there's that. I don't know whether or not you can prove that anyone did it. Maybe you can't prove anyone did it. That happens. Maybe you just can't make a case against anybody, but that's your problem. So, you're the DA. I mean, you should know that. That's your problem. Your problem is to figure out, is able to find a narrative that you can prove beyond a reasonable doubt. If you can't do it, well, that just sucks. It's too bad, I guess. Oh well. All right, pressing on.
They are witnesses doing what our justice system asks of them. The autopsy of John O'Keefe was conducted by a forensic pathologist from the Office of the Chief Medical Examiner.
Okay.
The doctor found that the injuries that left John helpless in the cold were not a result of a fight. She further found...
Is this the first autopsy or the second autopsy? Because or when they changed the results on the autopsy, which one? Was it like initially with the initial results, or was it when they changed the results of the autopsy? Couldn't help noticing that happened. After, incidentally, they had communications with the lead detective and some other people, which is also, a little bit suspect when he himself is suspect. So there's that. Okay.
That the line of abrasions on his arm was consistent with blunt trauma, not an animal attack.
Guys, I'm not an expert in this area, although I did stay at a Holiday Inn Express last night, so I'm at least as qualified as some of the prosecution's experts. So if the defense wants me to testify as an expert witness on the dog bite wounds, I'm available. That being the case, however, you're telling me that those vertical scratch-like marks are due to a blunt object. The blunt object left multiple distinct scratch-like objects, scratch-like indications in the skin. The blunt object presumably being the car. Okay, I'd like someone to explain to me how does that work? How does the car create those striations? Anyone got any ideas? I'm at a loss. So I don't think it was the car. I'm not really buying that one. But okay, sure. The car did it. All right.
A grand jury of everyday citizens heard the documented evidence and testimony before making a decision.
That is a weak-ass argument, and you know it. Grand juries, first of all they have to do is find probable cause, and it's only the government that presents evidence. As they say, a ham sandwich could indict, because it's pretty easy. It's not meant to be hard. I mean, in particular, it's not supposed to be very much. It's just probable cause. Probable cause is like, 1, 2 out of 10. It's not much. It's very low standard. So it's like, could you get And also, incidentally, even then, you only need a majority of the grand jury. You only need 12 of the typically 21 people that sit on a grand jury to vote yes. So you need 12 out of 21 to vote, or 12 out of 23, sorry, 12 out of 23 to say yes to a preponderance evidence standard, which is like 15%. It doesn't take a lot. So a grand jury voted to indict. Oh yeah, I'm totes sold, yo. That definitely is the same thing as beyond a reasonable doubt. Let me tell you what. Oof.
The subject of that murder indictment enjoys the constitutional presumption of innocence.
Yeah, I mean, they are supposed to enjoy the constitutional presumption of innocence. That is definitely a thing. Yeah. I have some questions relating to your burden. I have many questions. Most of them are evidentiary in nature. Like, you want me to convict her on this evidence, really? With the solo cups and the missing logs and the evidence floating around in someone's trunk for a month, and the lab doesn't know which cup they test, and the leaf blowers and the rakes and the guy who destroyed his cell phone and the so forth and so on. House long to die in cold. Yeah, you want me to convict on this? I'm not really feeling it, man. Not feeling it. Okay.
Witnesses who have committed no crime be afforded less by members of the community. They should not be harassed for telling the government what they heard or saw.
I would say they shouldn't be harassed, but I would clarify that slightly. I mean, I just don't think people should be harassed in general, but I don't like that he says they shouldn't be harassed because of what they say they saw. I mean, if you're going to say this, it would be because they told the truth, which is deeply questionable. I don't think they should be harassed in any event. People just generally shouldn't be harassed. But his rationale for why they shouldn't be harassed in particular is not the strongest rationale.
I'm asking the Canton community and everyone who feels invested in this case to hear all the actual evidence at trial before signing guilt to people who have done nothing wrong.
I did that. I watched the entire trial, and I watched it with you, and I have many videos on my channel relating to it. I watched the video. I watched the entire trial. I watched every moment of that trial. And once again, having some reasonable doubts here. Having just a few doubts based on reason. Yeah, I don't. Also, it's not really my job ultimately to assign blame. This is also a mistake. See, and this is also the jury's mistake to some degree. It isn't the jury's job to figure out who done it. It isn't the jury's job to figure out which story is the most plausible story and then vote with that story. That is not their job. Their job is simply to figure out whether or not the state has proven beyond reasonable doubt as to each and every element. That is it. They don't have to figure out who did it. They don't have to figure out whose story makes the most sense. They have to figure out whether or not the state proved beyond a reasonable doubt as to each and every element. As to that, I think they came pretty woefully short. But maybe it's just me. Since apparently 8 members of the jury were ready to convict on manslaughter based on what? Apparently, John O'Keefe was there, Karen Reed was there, therefore Karen Reed did it. Yeah, okay, pressing on.
And certainly, before taking it upon yourself to harass...
Do I ever go on any channels to review the other side? No, not really. You only see me on Free Karen Reed channels? Well, that's because that's the side I tend to agree with the most. Having watched the entire case. I mean, at this point, I suppose if someone has a really good argument for why the state proved each and every element beyond a reasonable doubt, I suppose I'm interested in that argument. But I don't know what that would be, because I mean, I watched the case for myself, and my concerns are principally evidentiary in nature. It's not even principally credibility in nature. So if it was principally credibility in nature, like compare, for example, the Black Swan trial, where ultimately, at least in my humble opinion, it comes down to a credibility question of like, do you believe the the ballerina or don't you? Right? Because that's sort of like the end game. In my humble opinion, it's a credibility determination. So there are some people who think that she's not guilty. And then there are people like me who think, no, I think the state proved it beyond a reasonable doubt. Because it's ultimately like a credibility determination. It's ultimately like, do you believe her or not? Because in the end, she's the only witness to what happened in that room, right? That's like the end game. So, because it's not a question of whether or not she killed him. We know she killed him. It's a question of whether or not she had self-defense or not, right? So it's like a credibility question at the end of the day. So I'm not necessarily opposed to going on a channel that can provide a coherent case as to why Karen Read is guilty as to each and every element of the charge beyond a reasonable doubt. But they're going to have to get past the many evidentiary problems, which are creating real problems with that. So I'm not sure how you get there. But if anyone knows of anyone who's like credible, who believes Karen Read is guilty because they believe the state has proven it and, you know, walks through in a constructed legal analysis, preferably legal analysis would be nice, or at least a logical analysis. If they can lay out a logical case why they don't have reasonable doubts, I suppose I'm interested in that. Could be fun. Let me know if you got anybody like that. Let me know. If it boils down on their end to, I believed, you know, McCabe, it's like, well, I guess if you believe McCabe, I guess, but you know, with every other evidentiary problem in hand, I don't know that you can really get there even with McCabe. But I suppose if you believe her, but you know, I didn't really find her particularly credible. But maybe just me.
Citizens, who evidence shows, have done nothing in this matter but come forward and bear witness. We try people in the court and not on the internet for a reason. The internet has no rules of evidence. The internet has no punishment for perjury.
Yeah, but the court is supposed to have rules for evidence, and in this humble lawyer's opinion, their application of their rules of evidence is questionable. Not for a least of reasons as authenticity. Authenticity, how do we know this evidence is what it purports to be? And again, with the missing logs and the missing data, and we're not sure which cup it came from, and you know, all those issues, authentic, and the Sally Cam port with the missing tape and ghostly appearances just appearing randomly on tape from apparently nowhere. Authenticity is actually a pretty reasonable problem for many of the pieces of evidence that apparently were offered at case and the trial judge accepted. I have authenticity problems. You're supposed to have rules of evidence, including authenticity, but the judge doesn't seem to have the similar authenticity questions to me for some unknown reason.
And the internet does not know all the facts.
I know all the facts now. I watched the trial. I watched it. I know everything there is to know. I think. I mean, pretty much. Okay.
Conspiracy theories are not evidence.
Conspiracy theories are, in fact, not evidence. That's fair. Again, I don't necessarily have to know who killed Karen Read. Not my job. Not my circus, not my monkeys. My mission in life is not to figure out who killed John O'Keefe. Not my mission. Within the confines of Commonwealth versus Reed, I have but one mission. It is clear. My mission is clear. Did the state prove it beyond a reasonable doubt as to each and every element? That is my only obligation. If Karen Read did it and she gets away with murder, that's the right answer. See, this is where I think people sometimes have a bit of a problem. Right? The state's burden is to prove it beyond a reasonable doubt. So even assuming Karen Read did it, and even assuming that means she gets away with murder, if the state can't prove it beyond a reasonable doubt as to each and every element, then yes, she's supposed to get away with murder. That's the correct answer. That's the correct answer because the state didn't meet its obligation. Okay? That's the answer. Okay? So I don't want to know whether or not you think Karen Read is the most likely suspect. I don't want to know whether or not you think the state story is the best story, because I don't care. Just because it's the best story doesn't mean it meets the burden. Best isn't necessarily good enough. We have rules here, people. We live in a society. Bam.
idea that multiple police department, EMTs, fire personnel, the medical examiner, and prosecuting agencies are joined in or taken in by a vast conspiracy should be seen for what it is.
It doesn't necessarily have to be a vast conspiracy. That's another thing too. It doesn't necessarily have to be a vast conspiracy. I'm not sure what the minimum number of people here have to be involved in order for like the Karen Read was framed thing to be true. But it doesn't necessarily have to be a vast conspiracy. A couple well-placed people can do the trick. So maybe it's only 2 or 3 people that are at the heart of this thing. And maybe that's enough. Maybe everyone else is an honest broker. You know, it's like, to some degree, how many people do you think it takes? Right? How many people do you think it takes? Sometimes it doesn't take that many people, man.
Completely contrary to the evidence and a desperate attempt to reassign guilt.
Again, not my mission, not my circus, not my monkeys. I am not here to reassign guilt. Not my job, DA. I only want to know, did you prove the case beyond a reasonable doubt? That's all I want to know. Please stop asking me other questions. Not my job. Thank you.
Michael Proctor, the state police trooper, being accused of planting evidence outside 34 Fairview Road, was never at Fairview Road on the day of the incident. Proctor and his state police partner traveled together the entire day while other officers were processing 34 Fairview. Trooper Proctor was not there and did not plant evidence at 34 Fairview Road.
Okay. Well, all right. Okay, fair enough. Let's go with the presumption then that what did we wind up with? 47 pieces. Let's go with the presumption that all 47 pieces really were there the entire time, even though we found 0 pieces initially, and then I think we found 4, and then I think it was 9, and then I think there were some other numbers in between, and eventually we wound up at 47. New pieces reappearing all the time magically. It was amazing. Let's go with they were really there the whole time. Sure. Okay. All right. Karen Read wasn't framed. Okay. I still don't care. I still don't care. See, you're not getting it, DA. You're not getting it. Once again, I don't have to figure out whether or not Karen Read was framed. I don't have to figure out whether Proctor planted evidence. The defense has no affirmative burden here whatsoever. I can just go with the fundamental question of, did you prove the case beyond a reasonable doubt as to each and every element of the charge? So sure, Proctor didn't frame Karen Read. Let's go with that. The tail light pieces were there the entire time. Let's go with that. I still have many evidentiary issues relating to solo cups and missing video and ghostly presences and missing logs and authentication problems. 4 days, just 4 days, so many authentication problems.
In addition to having no opportunity to plant the evidence, as has been suggested, Proctor would have no motive to do so.
Well, I mean, if you want just like a simple, like, if you want just like the most innocent motive, I don't even know that you would call it a motive, but tunnel blindness can get to everybody. So it doesn't necessarily even require Michael Proctor to necessarily be corrupt. He could just be a person who landed on an answer and then confirmation bias took over. It can happen to anybody. So it doesn't necessarily require him necessarily to be corrupt. It just, he somewhat hastily, in my opinion, came to a conclusion that it was the girl and then, allowed his cognitive biases to dictate his results. It doesn't necessarily require him to have some sort of grand arcing villain-like trait. It could just be he's a human being That's the most generous explanation. It gets worse from there.
Trooper Proctor had no close personal relationship with any of the parties involved in the investigation and had no conflict.
Okay.
And he had no reason to step out of this investigation. Every suggestion to the contrary is a lie. This should be seen for what it is and not used as a pretext to attack and harass others. What is happening to the witnesses, some with no actual involvement in the case, is wrong. It is contrary to the American values of fairness and the constitutional value of a fair trial.
You know what I think is contrary to the constitutional promises of a fair trial? Well, not turning all over all the evidence you have, not following Brady and Giglio, that's a start. Evidentiary problems and, okay.
It needs to stop now. I am releasing this recorded statement rather than holding a news conference because my remarks need to be so narrowly tailored to the issue at hand while the prosecution is pending in Superior Court.
I mean, I do appreciate that you as the prosecutor have to be careful on the statements that you make because you do have special ethical duties. So I appreciate that you're at least trying to be somewhat cognizant of that. Could do better on some of the other things, but at least you're trying somewhere. That's nice.
But the message is the same. What is happening to these innocent people, these witnesses, is wrong and it needs to stop.
Okay. Well, all right. Well, thank you for that interesting statement, DA Morrissey, from about a year ago. Interesting. Yeah, that was from March 31st of 2024, so almost a year ago. Yeah, I have many, many issues relating to the things that are happening in this case. And I don't know, ultimately for the purposes of our discussion, really fundamentally don't care about whether or not there was a frame job or not. That's someone else's job to figure out, not my job. It's like, I just can just stick to the fundamental question and call it a day. It's like, questions clarify. They clarify and they refine. It's like we can boil this down and make it really easy, right? We don't have to overcomplicate our lives. So, yeah, I didn't find the evidence in any way particularly convincing. And it did seem to somewhat defy the laws of physics. And also, of course, not for nothing, this 25-mile-an-hour reversing Lexus, this 5,000-pound car probably, hitting this person caused no bruising and no broken bones. That's amazing. That's amazing. It's like, but it did cause the severe multiple linear gash wounds. The Lexus did that apparently. How did it do that? I don't know. It just did, I guess. It just did, to quote Trooper Paul. I mean, that is the answer. So, but yeah, no bruising, no broken bones from this crash that supposedly happened. That's pretty phenomenal. Yeah. So all that stuff. Yeah, FBI doesn't announce their investigations closed. That's not the way the FBI rolls. It's standard policy by the DOJ. The DOJ typically does the standard policy. There have been a few occasions when the DOJ has deviated from that policy, but they don't. The DOJ, neither the FBI nor the DOJ typically comments publicly themselves relating to the closing of an investigation. But what they will do is they will talk to other law enforcement authority and they'll tell them that they closed the investigation. So yeah, the prosecutor representing that the investigation's closed is about as good as it's going to get because that's standard DOJ policy. The DOJ does not typically comment about investigations being open or closed. The FBI typically does not comment about investigations being open or closed. The FBI may have investigated you and you have no idea because that's just the way the FBI rolls. They don't announce what they're doing. Like most law enforcement, they don't announce what they're doing. That is by far and away the exception. So that is where we're at. Did I ever try to back up at 27 miles an hour? No, that sounds incredibly frightening. That sounds insanely frightening, especially in snow. But was it even snowing that evening? If only the prosecution had put forward some evidence that it was snowing that evening. Yeah. The FBI cleared Karen. First of all, the FBI wasn't investigating Karen. They were investigating, if they were investigating, they were investigating the police department. And again, this is an issue of nomenclature, right? I don't know whether or not they cleared them, and you can't really infer that from the investigation being closed. It just means that the DOJ did not come to a place where they were satisfied themselves to bring charges. So, you can't conclude from the investigation being closed that the FBI or the DOJ doesn't think that there's evidence, perhaps even substantial evidence, that might implicate someone in a federal crime. You just can't conclude that. The only thing that you can conclude from the investigation being closed is that the DOJ, who actually takes the standards pretty seriously, does not believe that there's beyond a reasonable doubt evidence to convict with each and every element. Because the DOJ tends to be very small c conservative, and that's true across administrations. The DOJ doesn't really like to lose. There's a reason that they have a 99% conviction rate once you factor in plea deals, and 93% without them. The DOJ doesn't like to mess around. So the DOJ tends to be very small c conservative, and they don't like to go after people typically unless they have you 5 different ways. That's just the DOJ's MO. They tend to be restrained typically. Exceptions do apply, but typically. So, like, all you can really infer from the fact that the investigation is being closed is that the DOJ was unable to satisfy themselves to their standard beyond a reasonable doubt, and so didn't bring the charge. And now it might be the case they found absolutely nothing. That might be true, but you can't really infer that. All you can really infer is that they didn't find enough to make the case to their own standard. Does the being closed mean the info comes out? No, absolutely not. Absolutely 100% not. No. Neither the DOJ nor the FBI releases information relating to an investigation once it's closed because it would be way too prejudicial. Right? They'll be way too prejudicial. They don't do that because they don't want to rake someone over the coals based on insinuations, right? They don't want to release information. It's like, assume the FBI believes that, someone in the Canton police is corrupt and, justifiably so. If they put that in a report and that got publicly leaked, that's not fair. And it's not fair. It is not fair to the person because there's no way for them to rebut that, right? They're not being charged in a courtroom. There's no way for them to rebut a report. So it's not fair. So the DOJ does not release its evidence, when the investigations are closed. That's just not how it works. The Fed case is not closed. Okay, if you say so. I mean, the prosecutor here said it was closed, and he made an affirmative representation to the court. It was closed. So, I mean, he's retracted other statements, but he hasn't retracted that statement. So, amazingly enough, I'm going to take him at his word, which I know is a scary proposition, but I'm going to do it anyway. So, Didn't he break the rules about what they can speak about? He lied about the Emmys testimony, named witnesses, and elevated them beyond reproach. I don't want to get into the finer points of whether or not he committed an ethics violation. Most of his statements were not about the defendant. So probably not. He probably didn't violate his statements. I mean, I could go through the finer points of the ethics rules, but probably not, because his statements were principally not relating to the defendant's guilt, but related to the witnesses, and they're probably okay. But I could read through the rules, but it's closer. He's liable multiple times. He's certainly misspoken at least multiple times. That much is true. Martha Stewart stated that the FBI said the case was closed. 3 weeks later, she was arrested. Well, Martha Stewart is not a governmental actor. So it's a different posture. The DOJ typically does not communicate to potential suspects that investigations are closed. That's just not their MO. It's not what they do. So I don't know how Martha Stewart thought she knew that, but she almost certainly didn't get told that by the DOJ. So, because it's just not how the DOJ rolls. The wording stated complete and will be closed. Okay, maybe. Let's check out Lawyer Knows response. Okay, which one? I'm happy to do a little Lawyer Know action. It's been announced publicly by the DOJ. It's been announced publicly. Because that's different. Do you know if it means there are no indictments under seal? Well, if the investigation's closed, there wouldn't be indictments under seal. They wouldn't say that. You did a video on it this morning? Okay. Do we really want to watch a 43-minute video from Laura, you know? I mean, I don't necessarily want to watch his entire video. Is there a particular part you want me to react to? Because I'm not sure I necessarily want to react to 43 minutes completely. That doesn't sound necessarily correct. Canton Police Chief release. Okay, there you go. Yeah, Canton Police Chief release. So there you go. That's probably sufficient. Yeah. So the Canton Police announced the investigation's been complete. Yeah. I was trying to see if I could find an official copy of the actual statement. The investigation is active and will be closed, said Rafferty. I don't know what will be closed means, as opposed to closed. Watch the video from Court TV. They just did an interview with Karen Reed, juror. God help me. Fine. Where is this? I don't see it on their page. Is this the one we already responded to, or is it something else? Okay, here we go. 3 days ago, Karen Reed, trial juror, speaks to Vinnie Politan on closing arguments. Is that the one you guys want? We could react to that. That's 44 minutes. I don't mind ripping off Court TV. Can't trust anything a cop says. It's an overstatement, but you know.
Karen Reed was accused of count one.
Oh yeah, this guy with the bow tie guy. I'm gonna, all right.
So we all raised our hands in terms of a vote, and we voted on that first count that we all agreed not guilty. Unfortunately, at that time, we did not fill out any of the paperwork there, nor sign it. So we were under the understanding that each charge could not be treated separately. And so we continued to deliberate, despite the fact that we had agreed on 2 of the counts as not guilty.
And the second count was count 3, and the same process where I guess the foreperson is asking for a vote and everyone raised their hands?
And everybody agreed not guilty for those 2 charges. That's correct.
Was there, now you mentioned that you didn't fill out paperwork. Was there any discussion about should we check the box on the verdict slip?
So we didn't check the box on the verdict slip because we were still deliberating on the second charge of involuntary manslaughter, and that continued with deliberation. We did send out notes asking for clarification, but unfortunately we did not ask the question at the time, should we treat each charge individually and separately?
So explain to us why the presumption was that you had to come to a conclusion on all 3. Was there any debate among the jurors about, and our diligent response were you expecting? Did you have any expectations about what would happen after?
Essentially, a decision that would be unanimous, and therefore it would be a futile exercise in terms of, and that's the unfortunate thing, is it wasn't clear that that was only on 1 charge. It clearly is indicated by all those notes. It seems like we were in deliberation and we were in impasse.
Stop skipping. I'm getting to the part I care about. I'll do whatever I want. If you don't like it, you can watch someone else. Screw off.
On all 3 charges, but that was
everyone who's looking at that is saying
each other, and hence the she was operating a vehicle.
And we're having trouble dealing with the charges as opposed to saying the charge or count 2. Let me ask you this. As you all were focusing in on that second count, what was the debate there?
See, this is the part I want to know, right? This is why I skipped it, because I'm like, this is the part I want to know. Why were 8 people ready to convict on count 2? That's what I want to know the answer to. So, okay, sell me.
You looking at, and how close were you? What charge were you considering in that second count?
I believe that most of us felt that she was operating a vehicle under the influence of alcohol.
Okay.
And that played into it. However, to some individuals, there was reasonable doubt on the mechanism to which Mr. O'Keefe actually succumbed and died. So I think that...
Like, namely, did she hit him? Like that kind of mechanism? Yeah, I have some reasonable doubts on that too.
Had a play as well. So
yeah,
those were some of the factors that were being discussed in that jury room.
So it's 12-0, 12-0, not guilty on 1 and 3. Let's go to count 2. What was, by the time you finished, after all these notes and the deliberations, what was the split, and how many, and what exactly was each faction voting for?
It kept changing. At one point in time, it was split 50-50. And so 50-50 initially, 6-6, then started to, based on debate and deliberation, it became clear, and we all kind of agreed that she was operating, or anybody for that matter, if they were operating a vehicle during that time frame and with all that alcohol, was probably under the influence of alcohol and should not be operating a vehicle.
If we were trying to convict her of DUI, that would be good, but we're not quite that. So what else?
Then it changed to between 8-4 versus 9-3. And ultimately, I don't think we came up to a final conclusion on a final tally as a direct result of it continued to be stuck. And it was very clear that some people were under the mindset and the belief that she was not guilty. And so at that point, those notes were continuously passed, ultimately with the final note.
And I've heard different things at different points about what the guilty votes were for. Was it for the top count was it for the top charge in count 2, or any lesser included charge within that second count?
So it was, I'm sorry, can you clarify?
Where you have 6, then 8, then 9 people believing she's guilty. Was it guilty of the charge in count 2 or a lesser included charge within count 2?
It was a lesser included charge within count 2 at one point.
Okay, we've gone through the deliberations. When we come back, Ronnie, what I want to do is go through some of the moments and some of the...
I don't want to go through some of the moments. I want to know how you guys were convinced beyond a reasonable doubt that she hit him. So I'm not going to get the answer to my question. That's, okay, you believe that she was drunk. Okay. All right. Okay, cool. She was drunk driving. Okay. All right, cool. There's still some other elements to the charge. There's still some other elements to the charge. So could you walk me through those elements? I'm not going to get the answers to my questions, am I? So I don't want to walk through the trial if we're not going to get to the thing. Yeah. I know she wasn't charged with DUI. I know that's my point. I'm like, there's other things. It's like, okay. It's like, can we get to how did you conclude beyond reasonable doubt she hit him? How'd you get there? Yeah. So none of these answers are encouraging. Yeah, it's an element, not the element. Exactly, right? There are other elements to the charge. Each and every element, guys. Each and every element. Right? There are other elements to the charge. It's like, how are you getting to she hit him? How are you getting there? Yeah, they didn't understand the assignment, felt like she had to be found guilty on something. Yeah. See, that they don't understand the assignment, even though the assignment is particularly well explained in Massachusetts, which is so frustrating. Like, Massachusetts has one of the strongest instructions on beyond a reasonable doubt of any state. Their instruction is incredibly strong. Moral certainty. It's like you had moral certainty. It's like I want you to tell me that you have a moral certainty that Karen Reed hit him with the car. Based on what? What is your moral certainty coming from? This is what I want to know. Yeah, I saw this on AK's podcast. Jurors said it came down to the fact that K dropped off J.O. Therefore, they're both there, therefore guilty. Yeah, I know. Like, because they were both there at the same time, that means Karen Reed is guilty. That is definitely not how that works. So yeah. What else can I react to? We could try watching the rest of the Turtle Boy interview that I gave up on earlier. We could pick up wherever I left off in that interview if we want to watch more of that. But I don't know that I really want to watch anymore because I can't be understanding. You understand lesser included? The charge included subcategories. There were lesser versions of the same charge. There's like 3 or 4 versions of the charge on the verdict sheet. Let me see if I can find the verdict sheet real fast. I'll show you. Okay. All right, here you go. All right, so, okay, how do I make this pretty? All right, this will do. All right. All right, so here's the verdict slip. Here's the original verdict slip. Now, they did change this verdict slip because this is how the verdict slip read originally. And then the defense wanted it changed to say not guilty of manslaughter or any lesser included. So this is version 1 of the jury sheet. But yeah, manslaughter while operating a motor vehicle under the influence. And then, of course, it defines what that is in the instructions. So your options were not guilty, which then that language got clarified to be a little bit clearer. And then, okay, guilty of the, and then you have 3 options. So not guilty of everything. And then you have 3 options. Guilty of the offenses charged, manslaughter while operating a motor vehicle under the influence, manslaughter while operating a motor vehicle under the influence, and or manslaughter while operating a motor vehicle with a blood alcohol of 0.08 or greater. So one of those things, right? So that's one version of the charge. And then we have the lesser included of involuntary manslaughter, which no longer you need necessarily be drunk. And then we have also a lesser of motor vehicle homicide, felony driving under the influence and negligence. And then you have motor vehicle homicide by operating a motor vehicle under the influence and with 0.08 or greater. So that's what they mean by lesser included. So there's the offenses charge and then 2 lesser versions of the charge. But all lesser versions of the charge require her to have committed the offense. So yeah, so that's the thing. So hopefully that clarifies that. And they were hung on 4. Well, maybe they were hung on 4. I don't know. I don't know whether or not. But even then, like, okay, you still need the motor vehicle homicide. This is what I'm saying. So you still need the homicide by the motor vehicle. So that still means that Karen Reed has to hit him with the car. Karen Reed hit him with the car is in every single charge. So it's like, you got to find one of those things. Yeah. They never proved that she was drunk. Well, that's debatable. I mean, that's debatable, but it's still not my major contention, right? I'm going for the lowest thing I can find, right? I'm doing what all good courts do. I'm trying to find the lowest thing that resolves the issue, right? What is the easiest way? What is the easiest way for me to resolve this case, right? And so for my money, the easiest way to resolve this is, did she hit him with the car? That's the easiest way to resolve it. So it's not the easiest way for me to say, was she drunk or not? That is not the easiest way. So I'm picking, did she hit him with the car? Because physics as the easiest way to resolve the case. And then I don't really care whether she was drunk or not, because what do we have to prove? What do we have to prove? Guilt as to each and every element. So I no longer care whether she's drunk or not, because if they don't prove she hit him, it doesn't matter whether she was drunk or not. Right? Because we've already failed one of the elements. So we can stop talking. We can stop talking and we're done. It's great, right? It's like we made our life easier. We make our lives easy as possible. Lesser includes are confusing? Maybe. But they were explained to some degree in the charges. Bev told the jury if she did something that led to her death, she's guilty. Her jury instructions were totally effed up. Maybe. I'd have to go reread them. What would I do differently as the defense? I don't know. I don't know what I'd do differently. The only thing I can think to do differently is not start off with the affirmative case, because the only thing I can think to do differently is defense by saying Karen Read was framed. The jury might have thought that they were under some obligation to prove that, which they are obviously, which they're not. So maybe saying Karen Read was framed as your opening line was ultimately a mistake. You know, maybe the better way to go is just simply saying the state cannot prove its case. Maybe that's the easier one. So all those things. Have they found the jury questionnaire sheets? You mean the ones for the voir dire? Oh, I don't know if they're available or not. Probably are. What else can we react to? I've got 1,000 of you here and I'm not eager to give up an audience. So I'm happy to react to some other stuff. I just don't want to like just slog through 40 minutes of Lawyer Knows premiere. You have the voir dire sheets? I don't particularly want them, but if someone else wants them, you can post them on Discord. You post them on Discord. If someone else wants them, then they can download it from my Discord. That seems fair. So if you want the jury verdict sheets, then look on Discord. They'll be there for you. Put it on 4x speed. Watch the full Turtle Boy video. We could watch the rest of the Turtle Boy video, picking up where we left off from before. The Turtle Boy video made me sad. Has Judge Can decided there will be an evidentiary hearing? There is no evidentiary hearing. She's allowing the experts to testify. Did other motions get filed? There were supposed to be other things that were filed today, I think, but I didn't see anything from the docket. Who is Turtle Boy? He's a person who has reported on the case and brought a lot of attention to it. And he is the person perhaps that may be most responsible in some senses for exposing this case to the broader world. So that would be who he is. He is an interesting character, though. He's a 40-year-old calling himself Turtle Boy. I'm 44 and I call myself Uncivil Law. So what? Lol. You don't hate on the man for his name. He likes turtles. What's your problem? Okay, I'm having trouble seeing it in my feed, so yeah, I did react to what the verbal instructions. She did tell them to go by what she was telling them versus written, which I couldn't believe when she said that. I couldn't believe that she said go by my oral instructions instead of my written instructions. I'm like, did you misspeak? Because that's bizarro world to me. That is so bar. Yeah, I mean, I agree with you. I remember when she said it. I reacted to it at the time. I'm like, that doesn't make any sense. We go to all that effort to work on the written instructions, and then you say my oral instructions take precedent over written? That doesn't make any sense. That's stupid, man. Ron H for 999 said, love your take and humor makes it outstanding. Thank you. Yeah, it should go by the written instructions. So we spend so much time working on those written instructions. We spend a lot of effort working on those instructions. Is it a bad idea to have a check mark for hung? Is it ever done? No, it's never done. It's never been done to the best of my knowledge, no. Karen is already convicted and in jail? Since when? What are you talking about? Asked Bob. No, Turtle Boy, Karen is already convicted in jail. Did I miss a memo? What are you talking about? Paul Crook for 5 pounds says Proctor on Cross said he watched the video on his desk and it wasn't inverted in yellow timestamp. I'll assume that I don't remember that, but I'll take your memory for it. He means if Turtle Boy didn't exploit this, that Karen Reed would have been found guilty and being in jail if he didn't exploit this. Well, I don't know. I can't speak to that intelligently. I mean, Turtle Boy, like everyone else, has a fundamental First Amendment right. Now, I've taken no position and will take no position at this time as to whether or not he is guilty or even the probabilities with guilt with respect to a witness intimidation charge. I haven't looked into it enough, and I really don't want to get into the finer weeds of Turtle Boy. It's like I have enough Karen Reed drama in my life. I don't need to get so deep into Turtle Boy lore too. It's like I think I want to take a pass on that one. But that being the case, I will simply point out that Turtle Boy has a fundamental First Amendment right like anyone else, and he has an absolute right to discuss a legal case just as surely as anyone else does. And if he thinks it doesn't make sense to him, he's allowed to express that opinion just as anyone else. And if other people got interested in the case because he brought attention to it, then, okay, then other people got attention to it. But I haven't been following Turtle Boy, as I just mentioned. I haven't been really watching his videos. The one I've watched the most is this interview, and I haven't watched that all the way through. He just doesn't seem like my cup of tea. No personal offense, just not for me. And, so my opinion is not based on anything Turtle Boy thinks. My opinion is based on, watching the trial. So I can't speak to whether or not she would have been convicted in the absence of him bringing attention to it. But to the extent that he was the one that brought attention to it, I'm glad he did because, well, it was a trial I was really thrilled to watch and see this absolute S show just develop and continue to destroy. So, that's what I'm talking about. I can't speak to whether or not Turtle Boy spread fake news or not. I don't have enough independent information to speak to that issue. Again, I haven't really been watching Turtle Boy's videos. He's not my cup of tea. So I can't really vouch for whether or not everything he said has been truthful or correct. I don't know either way. But to the extent he brought this case to light, then, that's a good thing because he's brought to light that this is crap. So that's good. Will I be streaming the Karen Reed trial? You bet your ass. Where's this interview? Oh, maybe it's under his lives. Oh, there it is. Okay, I found it. All right.
In charge, in that some of us felt there was enough reasonable doubt, and some of us did not. And not that we're trying to coerce anybody or try to convince anybody to vote one way versus the other.
But did they understand what reasonable doubt was?
I think everybody had a clear picture of it. That being said, I don't know if everybody wanted to vote in a particular way based on the reasonable doubt.
Now you obviously were not sequestered, but you were not supposed to go home and watch any of this, consume any of this. I don't know if other jurors were. I'm assuming if you weren't, and even if you were, you probably wouldn't tell me, at least not on the show. So assuming that everybody actually followed, that order, they didn't read up about this case, et cetera, while this was going on. Do you think that, is it even possible for how do you guys do that? How do you go home every day and not turn the TV on and not have bias when it comes to this story during this trial?
So it was very interesting because we tried, or it was one of those things where you do what you're asked. And I think it was a honest and trustable jury in that we all follow the rules, which is not to watch TV, diet from that, diet from reading the news or any of the tickers, and not pay attention to those things. Or if something were to come up, we were required to report it as such, that we had some sort of interaction. But like I said, most of us, I should say all of us, were pretty good about it. And we just, dieted from the news and the media.
All right. So I'm sure a million people have questions. So I'm going to read some questions that we have from Turtle Writers in the chat here, because I'm sure there's a bunch. Okay. Our first one, this is a $10 one from Jay. And again, if you guys are going to write them in, keep them brief. I will not read your freaking paragraph questions, so keep it brief. So how do you overlook paramedics' omission of possible, this is from Jay for $10, possible vehicle strike in the report narrative? The radio report to the hospital and the other report are both available to be examined, and would have been two opportunities for this medic to have reported document if it actually happened.
So I think one of the things there is it would have been nice if that was all documented per se. Again, the jury is limited on what we are actually able to see in terms of the documentation. So we are only given a certain piece of the documentation, and majority of it is based on the testimony of the individual. So the individual can read the document, or they need to read the document and then kind of say it out loud to the jury, and that's what's provided to us.
Next question here. This is a random one. Lem sends for $50. Long time, first time. Could you please ask the juror if they ever followed Turtle Boy, Olivia Lambo, or Joe Flipperhead? Do you follow any of those accounts on Twitter? Did you follow Turtle Boy before any of this? You probably
No.
know who I was.
Sorry, first time to learn about any of those, and in fact, first time I learned about Dr. Turtle Boy was when I got contacted. So
well, thank you for respecting my pronouns. All right. So do you have
Yeah, people are asking, did I talk about the jury tampering thing? So there's the case on the jury tampering thing is really interesting. With what's his name, Proctor's boss, who Fanning, right? Fanning, Trooper Fanning, who was the head of security for the entire operation of the courthouse, apparently was the one who witnessed this. Or no, did he witness it, or did he hear it from or did someone tell him? I forget actually. I think someone told him, and how did they, of all the possible police officers to tell it to, why they tell it to that one police officer, right? So like someone told to him that one of the jurors who was dismissed had been doing something improper. I'm not even sure what exactly, but done something improper. And as a result of this juror was dismissed after a sidebar without questioning the juror. As memory serves, they didn't question the juror. Bev didn't question the juror. She just dismissed the juror based on this report without even giving a chance for the juror to be heard, even in chambers. Talking about the case, yes, something like that. It doesn't really matter exactly what it was. It's just, it was really, really weird. And so of all the many police officers and court officers or that this person could have talked to, they talked to Fanning. It's like, how would they know to talk to Fanning, right? And Fanning is the one that's reporting to this court. It's like, and even if you believe all that she didn't give a chance for the juror to be like, well, were you talking about the case or whatever? It's like really, really weird. Yeah. Talking about the case 3 weeks before, about the case 3 weeks before. Yeah. So, I mean, and then, so the whole thing is really weird. And this was apparently a really defense friendly juror. So there is this issue relating to jury tampering. That's an interesting question relating to that. I'm not sure you could ever prove it. But it's an interesting question. They didn't talk to Fanning. It was passed on to Fanning as head of security. So what are we dealing with? 3 levels of hearsay? So it wasn't Fanning who heard it. It wasn't someone talking to Fanning. It was someone talking to a police officer who talked to Fanning. So that's like 3 levels of hearsay? Because the original person isn't in court either. Right? If the original person was in court, it wouldn't be hearsay, but they're not. So it's like 3 levels of hearsay. Triple hearsay. Yeah, that's a lot. I mean, I've heard of double hearsay in indictments. I've heard of double hearsay, triple hearsay. Triple hearsay? I don't know, man. That's a lot of hearsay. That's a lot of hearsay. Yeah. 6 weeks prior? Yeah, even if the juror had been talking about it 6 weeks prior, that doesn't mean anything. If the juror was talking about it before jury service, doesn't necessarily mean they couldn't be biased. So even that wouldn't be enough anyway. That doesn't make sense. Yeah. It's a huge appeal issue? It could be. It could be a huge issue. Yeah. Because, like, yeah, you heard it from a guy who heard it from a guy who heard from a guy. I don't know, man. Yeah. And it's like, how does this original person know what a juror looks like? Right? Because their photos aren't published anywhere. And, well, I guess hypothetically, it could be someone who works with them and they notice they're gone for a long period of time and maybe put two and two together or something. I don't know, but it's a lot of conjecture. Yeah, it's a lot of conjecture. It's not an appeal issue because the trial's over and she's getting another trial. You're wrong. You're wrong. It is definitely an appeal issue, even if she's convicted, because she hasn't been heard on that issue yet. And so if that was done improperly, she can appeal on that issue. How so? Because she hasn't appealed on that issue yet. She hasn't been convicted. She hasn't appealed on anything. She hasn't appealed. The only thing that she appealed on was the double jeopardy issue, because that's allowed for interlocutory. So she hasn't had an opportunity to be heard on the issue of the dismissed juror. If that juror was dismissed improperly, if the juror was tampered with, especially if the jury was tampered with, then that might be a prejudice, because Karen Reed is fundamentally at baseline principles. Karen Reed is entitled to be tried by the jury that was selected. And so if the jury that was selected wasn't the jury due to an improper decision by the judge, and especially if it was witness tamper or jury tampering, then that would be a prejudice that would attach to Karen Reed. And she has not been heard on that issue yet by the appellate court. So she can still appeal on that issue. Yeah, she can still appeal on that issue. Now, as to whether or not the appeal will be granted is a whole nother set of issues. Like the Supreme Judicial Court, whether or not they'll grant it. Yeah, I mean, that's a whole nother set of issues, but she can appeal. She has the right. What would be the remedy? The remedy would be dismissal of the remedy would be dismissal, because it is irremediable. It's an irremediable injury. So the remedy is dismissal. So if she were convicted by a second jury and the first jury was tampered with, in this case by the government, because it was Fanning who's the government, right? And so the government caused the jury to not be the jury that it was supposed to be, then that meant that she was not tried by the first jury, which she was entitled to be. That injury would be irremediable, because a new trial doesn't fix it, because that jury's gone. We can't get them back. So a new trial isn't the remedy. Dismissal is the remedy. Because that's not what happened. Okay. Maybe it's not what happened. But all right, fine. Yeah. Yeah, the government can't mess with the jury, right? Especially the government can't mess with the jury. Like, it would be bad enough it was some random person. But if it's the government particularly, they obviously can't profit from their own misconduct. That'd be really dumb. Yeah. Sui Generous, $2 says, love your deep dives. Thank you, Kurt. You're welcome. Yeah. So that's the way I see it. Yeah, they would absolutely have to prove it, which makes it challenging. As I said, it's difficult. I said that already. I already said it would be difficult. Like it would be difficult to make the case. Yeah, it's problematic, but it's a viable ground of appeal. Is it likely? Not especially, but it's something. So that's what I think. I enjoyed my collab with Runkle. I always enjoy my collabs with Runkle. They're fun. Runkle's a good guy. I like him a lot. All right. So we can go watch more of this interview. It's definitely hearsay. And hearsay is an out-of-state court. Hearsay is an out-of-court statement offered for the truth of the matter asserted. That's what hearsay is. It's definitely hearsay. So if you guys are debating whether it's hearsay, it's totally hearsay. So you have the original person who says, I saw the juror talking about the case. Okay, that's your first person. All right. That person is not in court saying it. Right? It's an out-of-court statement. Right? It's being offered for the truth of the matter asserted. All right. So that's hearsay. Great. She or this witness told some cop. Okay. Now it's not, I saw it. That's hearsay level 1. It's, I heard it from someone who saw it. That's hearsay level 2. And then that cop told Fanning. Now it's not, I saw it. I heard it from someone who saw it. I heard it from someone who heard it from someone who saw it, who's not in court. So that's 3 levels of hearsay. Count it 3 times. 3 times. Right? And hearsay rules are different in trial versus not trial, to be fair. So, for example, hearsay is allowed in an indictment. Hearsay is allowed in an indictment. It's allowed in a probable cause because the standards are lower. So just because it's hearsay doesn't mean it's automatically excluded. But in this context, it doesn't mean it's automatically excluded. But it still has to be sufficiently reliable. And this is 3 levels of hearsay. It's triple hearsay. That's a lot of hearsay. I'm just saying, it's a lot of hearsay. It's like, why don't we at least call the officer, instead of Fanning, why not just the officer the person talked to? Then it would only be 2 levels of hearsay. That would be better. And the best evidence rule says we should get as close to the original as we can anyway. So the best evidence rule says, let's get as close to the original as we can. So if we can't, if we need to decide this issue right this second, and we can't get the witness, can we get the cop the witness talked to? Because that would be better. That's better evidence. So let's get them. And then we'd only have 2 levels of hearsay to be better. But that's not what happened. So it's a problem. How did the person know the person was a juror unless they'd been at trial? Well, the only other way that it makes sense is that they knew it because they knew this person otherwise from their personal life. And this person, suddenly vanished for multiple weeks and they put 2 and 2 together. So that's the only other way it makes sense. It's like a coworker or something. It's like, can't help noticing Bob's not been around for a couple weeks. Also noticed this case has been going on for a couple weeks. Maybe the 2 are related. Could be that, but that's the only other way it makes sense. Yeah, JI5 said if it was an issue, the defense would have relied upon it on their recent appeal. The defense has not appealed. Okay? That's not how that works. You can't just appeal anything at any time. There are rules. Okay? You can't appeal typically until a case is over. You can only typically appeal once the case is concluded. Right? If you want to appeal while the case is ongoing, it's called an interlocutory appeal. They're constrained. They're constrained. So they could appeal the double jeopardy issue because that would be non-remediable, which is an exception to the rule. It's non-remediable. The reason being because double jeopardy, the very thing double jeopardy protects you from, is from being retried, right? That's the whole point. Double jeopardy prevents you from being retried. So if you had to wait until the end of trial to appeal the double jeopardy issue, the very thing double jeopardy was meant to prevent would have already happened, right? So it's non-remediable. The appeal court can't fix it because the thing that wasn't supposed to happen has already happened. So it's an exception because it's a non-remediable harm. So she was allowed to appeal the double jeopardy issue because it's a non-remediable harm. And then because it was the basis of the Supreme Court's decision, the Supreme Court of Massachusetts decision, she then filed a collateral attack, not an appeal. She filed a collateral attack in federal court, raising that same issue on federal grounds. So she can't appeal the jury issue yet. I don't think she can appeal it yet. So that's my best opinion. So yeah. And they include the juror issue in the motion to dismiss, which also is non-appealable. The decision not to dismiss will not be appealable. So, yeah. Would Fanning be involved with the jury issue in his company with Crawford being involved? I don't know. It would be telling if the same judge gives different jury instructions? They may, and that may be due to the request of the parties. Not for at least the reasons is this going to be this partial verdict thing. I imagine that the judge is going to ask the defense whether or not they want partial verdicts, and in the jury's charge. And it'll be interesting to see, incidentally, what the defense says on that issue, because I don't know what they're going to say. I think they probably won't say they do, but the jury instructions might be a bit different. They can be revised if they need to be revised. So it's possible there might be some differences. What else? I'm having fun. For whatever it's worth, though, we've seen cases that are worse in terms of corruption. You know, we've discussed cases that are worse in terms of corruption. Like the Glossop case is arguably worse than Karen Reed. Not for at least the reasons it was a death penalty case. And Glossop has had his final meal 3 times now. And now we're back. Now we're going to have another trial. I think we're on trial number 3 now. It's not been going very well for Glossop. Glossop has had a bad time. Have I seen a weaker case on evidentiary issues? Not really. This case is special on evidentiary issues. This case might be the worst on evidentiary issues. This case is disaster fuel. Was this today? No. Glossop was decided by the Supreme Court about a week or 2 ago. U.S. Supreme Court was decided about 2 weeks ago. Delphi might be another example. Fair? Yeah. By the way, since you guys missed my stream earlier and I have 1,000 of you captive, haha, I did a little stream earlier on a case the U.S. Supreme Court just decided to take up review on. It's a really interesting case, and it's going to be super controversial. It's going to be incredibly controversial. Okay? So about a year from now, the Supreme Court's going to make a decision, and they're going to piss a lot of people off. Okay? So let me tell you about the case. All right. So there is a psychiatrist, a talk therapist. No, psychologist. The other way around. She's a talk therapist. She's a talk therapist in Colorado, and she's a Christian. And people come to her who believe that they're LGBTQ, young people under 18. They believe they're LGBTQ, but they don't want to be. They don't want to be LGBTQ. They think that their desires are unnatural and they'd like to not have those desires. And she, the therapist, would like to teach them how to not have those desires. She would like to give them talk therapy in order to help them not be gay or trans or whatever as the case may be. So the U.S. and Colorado has a law like 20 other states do, but Colorado has a law that prohibits the talk therapist from doing this. The statute in question says, essentially in so many words, you can't counsel someone to be other than their professed gender identity, but you can counsel someone to accept their gender identity if it's different from what they were born with. So you can't tell the LGBTQ kid that they shouldn't be LGBTQ, but you can tell them that they should accept their identity as LGBTQ, and they should do that. And the therapist has appealed, and the Supreme Court today decided to grant review on First Amendment grounds. Whether or not the First Amendment prohibits Colorado statute, whether or not Colorado can ban the talk therapy relating to trying to convince kids that they're not, in fact, LGBTQ, or they shouldn't be, or shouldn't have those desires, and so forth and so on. Conversion therapy, in other words. So, First Amendment issue relating to conversion therapy. And it's going to be, it's minors. It's people under 18. It's people under 18. So, it's going to be amazingly controversial. And I did a review of that earlier today, trying to discuss that case a little bit. And it's really, really interesting. It's going to be incredibly interesting. Yeah. And there's a circuit split 2-2 on this issue, which is one of the reasons the Supreme Court picked it up. So 2 circuits have said that it's protected by the First Amendment and they can't, and the states can't do it. And 2 circuits have said, no, it's not protected by the First Amendment and the states can do it. So there's a 2-2 split on the Court of Appeals right now. And so the Supreme Court has decided to come in and break the split. There's going to be a lot of really pissed off people a year from now. So look forward to that. Did the roast turn out good? It turned out acceptable. It wasn't my favorite thing, but it turned out acceptable. Is there a real person injured, or is this a made-up case? You mean manufactured? Well, first of all, even if it was a manufactured case, it still wouldn't matter. Manufactured cases have been well recognized by the U.S. Supreme Court. You know the most famous manufactured case of all time? You know what probably is the case that was completely manufactured. They created it. You want to know what case that was? One of the most manufactured cases of all time? Rosa Parks. Montgomery bus boycott. Rosa Parks was a manufactured case. Rosa Parks was chosen in advance by the NAACP to sit on that bus and not leave. There was another woman about 2 or 3 weeks before Rosa Parks who did the exact same thing. But the NAACP, I apologize, the NAACP didn't want to take her case because she was an unwed mother. So there was another woman whose name I've forgotten, and it's been forgotten to history because she's been forgotten. But she was an unwed mother, unwed black mother. She refused to leave, and she was arrested, but the NAACP didn't take her case. The NAACP recruited Rosa Parks. This is not controversial. This is documented history. Okay. They recruited Rosa Parks as a textbook, perfect person to sit on that bus and defy the rules. So there you go. One of the most manufactured cases of all time was Rosa Parks. So manufactured cases are nothing new in law. So, yeah. Yeah, today you learned. I know. It's like, yeah, it's not well known, but it's completely true. Look it up. Look it up. It's not controversial. Yeah, they don't exactly make a big deal of pointing it out, but yeah, it was a made up case. She got arrested. She absolutely got arrested. And the woman otherwise got arrested. They both broke the law. Of course they got arrested. She was a black passenger sitting in the white only section of the bus. Of course she got arrested. That was the whole point. That was the whole point. Of course she got arrested. Trump's New York case is manufactured. Well, if it is manufactured, it's manufactured in a different sense, right? Because it's manufactured in a different sense. Manufactured cases are where an attorney wants to bring a case and they create the plaintiff. They create the plaintiff to bring the case, right? It's my perfect plaintiff who is flawless. You know, another manufactured case in recent history was students for fair schooling at Harvard. The Harvard case that resulted in the end of affirmative action in colleges. Students for fair admission. Yeah, students for fair admission was a manufactured case. Also, ironically, what was the name of the case? Plessy. Was it Plessy versus Ferguson? Plessy was the train one, right? Plessy was the train car one, wasn't it? I think so. Yeah, Plessy versus Ferguson was the train car one, right? That was a manufactured case. They picked that person because they thought it was their ideal plaintiff. Now they lost, but that was a manufactured case. It went the wrong way, but it was manufactured. Yeah. So I mean, they picked someone to sit on that train car, and get arrested. That was a manufactured case. It went the wrong way though, but still. So all those things. Yeah. Plessy versus Ferguson. It's like, man, and Dred Scott, man, some of the language in those cases, holy shit, man. Some of the language in those cases is just like, wow, you forget how racist they are when you go back and reread them. It's like, holy shit, dude. Holy shit, they're pretty racist. The Mississippi pot roast was acceptable. It wasn't great, but it was okay. Probably needed more peppers, to be honest. All right, let's watch a little bit more of this interview while I'm waiting for more questions.
New donation from RNC.
Thank you, RMC. That's nice of you.
Now that the trial's over, have you consumed any of this?
And someone sent me a PayPal. I haven't gotten one of those in a while. Thank you for the $100 PayPal. Oh, that was the Ko-fi donation, was $100. Oh, that's really nice. I think. Thank you, Robin. That's very nice of you. Appreciate it.
Whatever.
I think, at least for me, and I believe the majority of the jury, we all wanted to just go back to our normal lives, and we haven't really followed much of it other than knowing full well, just occasionally, that it was a hung jury and that it's probably going to be retried, and we know that it's being retried and we know the date, but I honestly have not gone and searched anything or researched much of anything in terms of the case because I lived it.
Do you think if the defense had been allowed to mention that there was a federal investigation into the investigation itself and that the FBI paid for those ARCA experts to be there, would that have affected the outcome of the trial?
I believe that it would definitely have changed. Most likely would have changed the hung jury or made it more unanimous of a vote. So it would be easier to kind of look at, and they would still ask us to continue deliberation because it would just be a few individuals left.
Next one here. This is from $30 from Dawn. Could the juror confirm if the jury slip was the updated version requested by Alan Jackson, or is it the one that they never updated? Did you guys get confused by that?
Yeah, so we got two different slips. The first slip that we got.
Yeah, this was a huge point of contention for a long time. I was like, I told people, I remember fighting the chat on this so hard. Because I was like, okay, they corrected it. It's like, no, they didn't correct it. I'm like, yes, they did. They did correct it. No, there wasn't a not guilty option. There was a not guilty option. They added boxes. No, they didn't add boxes. They just changed the language. They didn't add boxes. The not guilty option was there the whole time. They just clarified the language. And people in chat were like, no, that's not true. I'm like, it really is, though. It really is true. Yeah, okay. I enjoyed fighting with chat many times on these issues. Damn.
Was updated and changed. I cannot recall the exact date or day that we were given the new slip, but we definitely were given a new slip that was updated charges and updated verbiage.
Okay. This is from Kim for $10. Says, what questions were you asked of when you were chosen as a juror? Good question. During the voir dire, when you guys were called up and your little conference there with the judge and the attorneys, what were they asking you? What questions?
I mean, each individual is different. I think the major question was for me is that would I be biased in any way, shape, or form because of my medical training, and so that wouldn't overlook the evidence and have an opinion and have a bias as a direct result of my medical training without looking at the evidence entirely and kind of do I have a bias versus or against or for law enforcement.
Who asked you that question? The Commonwealth or the defense? Do you remember?
I believe it was more of the defense.
Okay. The defense asked you if you had a bias towards law enforcement? Okay.
I believe it was the defense.
And you said you were just indifferent, whatever. Because if you said, yeah, my dad's a cop or something like that, you'd be the first one on the cutting line if you said something like that.
I don't know. Maybe perhaps I tried to be honest, I tried to get out of it. I actually thought I was just going in just the first day.
Under what legal theory did Bev rule that no one's allowed to talk about the federal investigation? Oh, yeah, it's irrelevant. It's irrelevant. And it is incredibly prejudicial. I wouldn't have allowed it either. I would never have allowed it either. That was not the wrong call. Yeah, the fact there's a federal investigation going on creates all kinds of problems. So I have no problem with them like excluding all. That's way too prejudicial. That is way too prejudicial. I wouldn't have allowed it either. Not a chance. The mention of it. I mean, obviously, I would have allowed the ARCA witnesses. I would not have allowed a mention of an ongoing federal investigation. That's okay. Absolutely not doing that.
I didn't even know what the whole thing was until at the end when they were starting to select us, what was going on. But I thought it was just going to be a regular jury.
Were you there April 16th, the first day of jury selection?
No, I was there on the second day, on the 17th.
Okay, the second day. They picked 7 that day. So that's interesting. So you went into that, and you must have seen crowds of people outside. Were you like, what the hell is this? What's going on here?
Yeah, I actually didn't realize what we were being selected for.
Prejudicial against whom? Prejudicial against everybody. It's prejudicial against everybody. It just inflames everything. It puts things off point. It doesn't help. It is also not relevant. It does not, the fact there's a federal investigation does nothing to either make Karen Read, to make it more likely or less likely that Karen Read did it. It is not relevant. So forget prejudicial. How about relevancy? It is irrelevant because it doesn't matter. It doesn't change anything. So, federal investigations happen all the time. It doesn't change anything.
Was the case until it was read to us by the judge. But essentially, I thought I was going to go in my typical jury duty, go in there and spend like maybe a few hours and then get out, be able to have lunch and have the rest of my afternoon, as opposed to the other way around where I was there for a little while for a full jury selection.
Next one is for Mackenzie, sends $5, and she kind of asks my question about the reconstruction experts, FBI, etc. And then she says at the end, like, how. She says, because I don't understand how someone could take Officer Paul's reconstruction seriously and disregard the 2 defense experts, because he was the only one that was the expert that explained for the Commonwealth. Yeah,
if you're going to believe Trooper Paul over the ARCA experts, I have many follow-up questions. Yeah.
How John O'Keefe got hit by a car. Did jurors actually take him seriously? Did they think his testimony went well?
Again, I don't think necessarily we were looking at one individual for their testimony. We kind of looked at the whole picture, bringing it back to the circumstance that somebody is dead, and those 2 individuals that came to that household or that address, one of those individuals is dead and the other individual is alive. Ultimately, and there's damage to the vehicle, then that individual must be responsible for that injury.
So, like, her dropping him off there, and whatever, like, that's not proof of anything, right? That's bad. That's, God forbid, like, I hope nobody else ends up in a situation where they drop someone up to the house and then they end up dead, and it's like, well, you dropped them off, so you obviously killed them. But you mentioned the taillight. That's the only real physical piece of evidence that they had against Karen Read. However, was it brought up during deliberations that the Canton police searched the scene at 7 a.m. with a leaf blower, and they videotaped it, and they didn't find a single piece of bright red taillight on the snow, yet they found 45 pieces over the next few weeks. Was there any discussion that perhaps taillight might have been planted?
There were some individuals that were definitely stuck on that and believed that was reasonable doubt, but there were some individuals that believed that it may have been, again, just...
Yeah, ARCA investigated the Challenger explosion. Yeah, they're probably pretty good. Yeah.
circumstance or happenstance, that maybe there wasn't enough snow at the time, and therefore now ultimately now the ground is covered, and therefore you couldn't see the pieces because it's covered. But prior to that, maybe now you can see it. So,
but they had leaf blowers and rakes, don't you remember? And also they couldn't see any pieces at all. Okay.
Well, it would be the opposite, because when the camp police got there at 7 o'clock, there was 3 inches of snow on the ground tops, maybe 4, 3 to 4. And it's a lot of taillight, right? And they had the leaf blower out, and they have a video of him finding these transparent pieces of cocktail glass. Paul Gallagher finds them. So they were able to find transparent pieces of cocktail glass, but not all that red taillight. Was the general consensus that the camp police are just completely incompetent? Wouldn't they have to be if they didn't find any taillight? Was that the consensus?
I don't think that was consensus. I think the consensus was just, again, they looked at all of the overarching evidence, not just that one little piece. So individual.
If you're looking at the I appreciate not wanting to look at just that one piece. My conclusions are not really based on one piece of evidence. I could let probably any one thing go. My problems are more systematic than that. It's like you're looking at everything and you can't believe that the police are, that they leave something to be desired. I mean, okay. All right. I guess the jury is very forgiving of the police. Very. A lot. Okay.
Looked at everything and said, nope, that's not enough to say that created reasonable doubt.
All right, next question here is from Melanie, sent $10. Goes, did he see the footage of Alan Jackson in court arguing with the judge about how the confusing juror forms were, and what did he think of that? Did you guys know that battle was going on inside the courtroom?
I do not know of that in particular. I never saw the footage, but I understand that it was very confusing. And again, unfortunately, it's a fallacy in the system that it wasn't clarified for us that we could look at each individual charge independently of each other.
Okay. Natalie sends $5 and says, what arguments or comments from guilty jurors led you to temporarily change from not guilty?
So to not guilty,
from not guilty to guilty.
Well, not guilty to guilty. I think ultimately, again, some of us broke down because it was very clear. They clearly displayed that both individuals were under the influence of alcohol at the time. And
I'm going to put that back at 1x. I need you to say that again for me, please.
they were under the. It was very clear. They clearly displayed that both individuals were under the influence of alcohol at the time, and therefore should not have been operating a vehicle. So the operation of the vehicle, and that is that second charge, which is involuntary manslaughter as a direct result of operating a vehicle under the influence of alcohol. So that is what a lot of people kind of swayed on, that yes, they shouldn't have been operating the vehicle, and it's not murder too, but could it be that she operated the vehicle negligently and therefore led to involuntary?
Negligently? I'd have to look up the statute, but I'm pretty sure you need at least gross negligence, which is recklessness. So yeah. So negligently is not enough.
Manslaughter. So that's where there could be a sway.
So it was the fact that she was, admittedly had. So I would say, so the testimony from the police about she had 4 drinks here, that was very effective, obviously, because ultimately they said, well, she was drinking and driving, so she probably did it.
I think it was not only that, but the video footage of the drinks that she was having was very strong in leading to that kind of opinion and thought process.
Okay.
We're really at the point where she was drinking, therefore she did it, right? That's what we're doing now. They do understand that she has to hit him with the car, right? They do understand that, right? 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 Okay.
Even though the rest of them were also drunk. I mean, everyone was drinking and driving that night, including the police, and that didn't bother anyone else.
I think it bothered everybody, but ultimately we have to look at who's being charged here, and the individual who was being charged was Karen. So unfortunately, nobody else was being charged with it. It was just Karen. So therefore, Karen must have been, and both people were there during that same time frame.
So that's
What the fuck?
We have to look.
police, and that didn't bother anyone else.
I think it bothered everybody, but ultimately we have to look at who's being charged here, and the individual who was being charged was Karen. So unfortunately, nobody else was being charged with it. It was just Karen. So therefore, Karen must have been, and both people were there during that same time frame.
So that's
Piece of fucking piece.
interesting that you say that because, and I've long argued this, that being in the defendant's chair is you're already losing. You're already losing. You're already down 20-0, something like that, because you're here. You've been charged. You probably did it, or else you wouldn't be here right now. So you would argue that the fact that she was charged at all and sitting in that defendant's chair and no one else was charged is pretty. That people were suggesting that was pretty solid reason to vote guilty.
I believe that it was a combination of, so theoretically anybody, right, should be considered innocent until proven guilty. But here they displayed clearly. So theoretically anybody,
pretty solid reason to vote guilty.
I believe that it was a combination of, so theoretically anybody.
Pretty solid reason to vote guilty.
I believe that it was a combination of, so theoretically anybody. Right, should be considered innocent until proven guilty. But here they displayed clearly, the Commonwealth displayed that she was under the influence of alcohol, even though there was no breathalyzer per se at that exact time frame when the incident occurred. Right, it was after the fact. But based on the evidence of the receipts and the video showing that she was under the influence of alcohol and then operating the vehicle, that would be easy to kind of charge her with involuntary manslaughter, operating a vehicle under the influence.
So. I have a question here from another juror. Is actually from one of the jurors who was not chosen to deliberate, and I'm getting a message from them now. And they said, this is the quote: "Did the jury ever discuss to a moral certainty as part of the reasonable doubt discussion, or would having an attorney in the room have been helpful for that?" Because I believe one of the jurors who was randomly chosen not to be in the jury was an attorney. So would it have helped to have an attorney in the room describe what to a moral certainty was? Was that discussed at all?
I think having that.
I really don't think you need an attorney to explain what moral certainty is.
That level of expertise in the room would have been helpful for everything, including the fact that, number one, that all three charges could be looked at independently, and somebody who has that level of expertise to clearly indicate to us the moral certitude of reasonable doubt.
Okay, because they went on to say that when we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs. So obviously, this discussion didn't even take place at all. What a moral.
So I won't say that it didn't take place because we read that statement multiple times to the group. I don't know if it hit home to the group more so if that individual was there to provide that level of expertise. So if somebody was there to provide that.
I couldn't speak to a Massachusetts lawyer because that's not vernacular that's typically used in law. This moral certainty thing is basically a Massachusetts specific thing. It's not, to the best of my knowledge, a legal term. And so I tell you what, if I was in the room, I would have nothing really substantially more to offer than that. Like, this is the standard you're supposed to use in your most serious affairs. It's like, okay, what is it exactly you want me as an attorney to do here? You want me to what exactly is it you're wanting me to explain at this point?
That level of expertise, I think it would have been more realistic or tangible to the jury or the group rather than not. Because although it was read multiple times, and I will say that we read it multiple times, and I was one of the individuals who was reading it multiple times. It clearly may not have made an impact or have been as impactful as if there was somebody with that kind of experience and that level of knowledge.
Yeah, coincidentally, she happened to be one of the two names chosen out of that box on the last day. And there was when I was watching the testimony of these people, there was 3 jurors in particular, all women, who were making visual representations with their facial reactions that they believed that Michael Proctor was an asshole and that the Commonwealth was full of shit and that Karen Read was clearly innocent. And coincidentally, all 3 of those people making faces were all chosen on the last day not to participate in deliberations. Did you guys did you guys ever talk about this before you started to deliberate? And what was it like the moment that you went in that room? Like, what's the first thing people said? Like, okay, so let's get this over with. Or what do you guys want to do first? What was that like?
We actually didn't. So in terms of just going into the room before deliberation, we really didn't talk much about the case when we were, other than a couple, comments here and there. And even when we were, when we were together, we were not really deliberating or talking a lot about the case. But we did definitely talk about the case during the deliberation process. And we tried to figure out where to start. I think ultimately we came up with looking at all the evidence and looking at the video files, looking at the pieces of evidence that was provided to us. And we kind of looked at all of those over the course of the time frame that we did our deliberations.
This is from Kelly. If Chloe Bit, you must have quit for $10, says, I want to thank you, Ronnie, for coming on to stand up for what is right in the name of justice. What was the biggest thing that caused you to believe in her innocence or that there was reasonable doubt?
Ultimately, what made me sway back to reasonable doubt was, yes, she was there and he was there at the same time frame. However, the injury that ultimately causes death was inconsistent with the physics of the damage to the car. And the other piece that causes death was the hypothermia. So those 2 pieces, which was presented to us.
Okay, that second one was a mistake. But you were doing good on the first half there. You're doing good on the first half. The second part was a mistake. Okay, if she had disabled him and then he succumbed to the cold, she'd be responsible for that. Right? So the fact that hypothermia is a contributing cause doesn't matter as long as she's a substantial contributing cause. So that second part was a mistake. But the first part, you were doing good. Like, the injury is inconsistent with the physics. Yeah, that was the problem. That was the problem. The injury is inconsistent with physics. I want to hear from one of the 8 jurors who wants to vote guilty. I want to hear from one of them. I want them to explain to me how the injury is consistent with the physics. That'd be good.
Was the basal skull fracture to the back of his head, and the hypothermia was inconsistent with the damages to the vehicle. And so ultimately, what I also thought about was that he was the one who kind of, and I'm not trying to put blame on him, but he ultimately was the one who was insistent to try to go back and go to this place. So for Fairview, he was the one who kind of programmed the GPS to that location. And she was the one who was asking to just go and have something to eat. Granted, it was a pizza place that was closed. She wasn't really looking to go drinking anymore. At least it seemed like it. He was and continued to party. So not trying to put blame on him, but it doesn't seem like she is at fault of whatever ultimately came about at 34 Fairview.
Because she just wanted to go home and eat food.
That's what it seems like.
Right. Okay. All right. Next up, this is from Nicole for $10. Says, "Hi, Ronnie. Thank you so much for your bravery coming on Turtle Boy tonight. In your opinion, do you think there's any possibility that one of the jurors who were firm on guilty could have ties to the McAlberts and thus already knew that they were going to try to vote guilty going into it?"
It's possible. I mean, it's a small world, right? So who knows?
Yeah.
I can't say that's speculation.
I'm just reading the question. I'm like, I don't really like that question because I don't know how you're supposed to answer that, but they gave it a shot anyway. Next one. This is B for $10. Says, this is a question I like. Would access to transcripts of trial helped change the decision or help you guys deliberate?
Yes, I think it would be helpful to see all of the transcript. It also is what people sometimes don't understand is the jury wasn't allowed to look at whatever was objected versus sustained in terms of there was some overrules that were there. So those had to be scratched out. That's why we had notebooks. It would have been nice to know ahead of time how long it was going to go, and we should have probably organized our notes a little bit better. So we did take notes extensively, but it would have been nice to have access to those transcripts to actually look through certain things as well. I don't know if it would have changed it ultimately, again, because of the unclear direction of the charges. So if we had better direction as well, I think we wouldn't be having this conversation right now.
I'm not sure that directions were your problem. There is no set of instructions I could possibly give. I have given up. It is hopeless.
And I think the trial would have been done last year.
Right. Romy sends $50. Says, "This is amazing. Thank you for speaking, Ronnie." People are very happy that you're willing to come on and talk. And you're not. I mean, good. I appreciate you coming on because this is nothing wrong with this.
Well, people say they're happy Ronnie is on stream. Well, I'm not sure happy is really the emotion that I would be going with. Crestfallen, despondent, resigned, fatalistic. These more accurately describe my emotional state rather than happy.
More jurors do this and talk about what happened. Are you worried about this? Were you nervous about coming on here at all? Were you apprehensive? Because when I asked you, you just said sure.
At the time when you said it, it wasn't anything of a problem. And then as it gone on, I was like, what could happen? But now talking, I feel relieved that I'm talking and letting people know the story. I think the story is important for people to understand and also to still believe there is, hopefully at the end, right, a good justice system.
I'm so mad. I feel like I can see the back of my own. I feel like I can see the other side of my eyes. I feel like I can see. I feel like I can see behind my own eyes. Is that normal? Is that a normal feeling? Am I having a stroke? Okay, I don't think so. I don't think it's a stroke yet.
And it works out because otherwise, if you look at it, she would have been imprisoned and because of what happened. And clearly, it may not have been the right choice. So I think, right, we will just have to let the next jury make the decision.
Did jurors not express any just general distaste for Karen Read? Because I've said this before, and I think Karen Read's biggest obstacle that she faces are the facial reactions that she makes in court. And I think some jurors, I know that one juror who was dismissed actually was dismissed because she made a comment to other jurors about Karen Read's facial reactions. Did that come up at all in deliberations, Karen Read's facial reactions in court?
I think not only her reactions, but other individuals' reactions.
Yeah, this guy's an EMT, isn't he? Isn't this guy an EMT? You grew up around doctors. This doesn't surprise you one bit. That's depressing. Aren't doctors supposed to be pretty smart?
I think it was interesting because we all kind of focused on certain people or certain things inside the courtroom, and there was family members' reactions, other individuals' reactions, but in terms of her specifically, I personally did not kind of put any kind of qualifier or quality.
Well, we know
to
you
that.
didn't. We know you didn't. But like, were the guilty people, like, did it seem like they just didn't like her, the tip of her sale, the way she looked, the way because she's not a typical murder defendant. She comes in court, she smiles, she makes faces, she doesn't cry. Did that rub some people the wrong way?
I think it probably solidified it for some, based on some of her reactions.
Nurses run the show. That can often be true. That's fair.
Okay. Do you believe that Brian Albert butt answered his phone while having sex with his wife at 2:22 in the morning?
I find that very hard to believe, but anything's possible.
Yes, and just asking. That's me. Wow, I see a bunch of people bringing that up in the comments. But okay, next one. This is from Denise Tuttle for $10. Says, does this juror think she was framed, and has anything he's learned since the trial changed his mind?
So, I think there's a lot of bias in the investigation, and therefore it's hard to go in that direction of. I think it created enough reasonable doubt in my mind that she was not guilty. Whether she was framed, that's a different scenario. But again, a jury would look at it and say that she's not guilty based on reasonable doubt. So,
that is the assignment. So, God bless you for that. God bless you for that. That is the assignment. You're right. You're not supposed to figure out whether or not Karen Reed is framed. All you're supposed to figure out is whether or not there's proof beyond a reasonable doubt. So you got a point. You got a point. Maybe my soul will be ascending from whatever level of hell I'm currently in. I'm not sure which level of hell I'm in right now, but maybe I can escape. Maybe there's hope yet. Or maybe this is false hope, only to plunge me deeper.
Is not guilty, then by definition, she had to have been framed because all that taillight got there, correct?
Correct.
Yeah, so it's just interesting. So it seems like in this situation, you either had to believe the McAlberts were honest or you didn't. And did the Google search come up? Because this Google search was what ultimately got me hooked on this case. That 227 Google search that came back as deleted. And then the deleted phone calls from Jennifer McCabe to her sister at 6:07 and 6:08, and Brian Albert not coming out of the house, etc. Did you guys discuss the behavior of the McAlberts and how suspicious it was?
We extensively discussed why was the first person to go to the house, approach the house, was member of the family, you know what I mean? And then the other pieces of the Google search, we don't know. And again, there was not an expert in the group necessarily that could talk about it with enough knowledge on experience, and that if those Google searches can track to the exact timeline and time frame and backtrack. So we're not really sure about that, but we looked at it and said, it's again, maybe just distractors.
That's what the consensus was, that the 227 Google search was a distraction?
Again, kind of distractor. I think some people were set at the very beginning that based on the evidence that they had seen so far, and kind of combing through some of the evidence, they kind of looked at it and said, you know what, both individuals were there at that particular address. One person was operating the vehicle under the influence, and another person is now deceased.
Wow. All right, next question here. This is from Not Man Shannon for $10, and says, if the defense took the time in closing to go over the jury instruction and relate each piece of evidence that establishes reasonable doubt to each jury charge, does Ronnie believe this would have helped the jury vote not guilty? I think we've kind of asked this already.
I believe that it would have probably been helpful to be able to have more of the data and clear instruction. So clear instruction, I think, would have ended up changing the scenario in terms of two of the charges, because we clearly said those two charges were essentially not guilty, right? So those two charges would be not guilty. The last charge, or the second charge, which is the involuntary manslaughter, I think if we had a level of expertise to ascertain reasonable doubt more tangibly.
The lawyers spend all this time trying to talk about reasonable doubt, and Massachusetts even goes one further with this whole moral certainty thing. And they're still like, we need to know what reasonable doubt is. I don't know what more we can do. I don't know what more the legal profession can do. I feel like we've tried everything. If anyone has any ideas of what we can do, let me know.
To each individual in the jury and a better explanation, then perhaps I believe that we would have been able to deliberate and go in one direction versus the other.
This is from Joan for $25 and says, knowing what you know now, what is your opinion regarding this case, and if you think he was hurt inside the house?
I think he wasn't injured by Karen in her vehicle. Where he was injured and who injured him, I don't know. And I think that's what law enforcement should be looking right at, is trying to figure out. Unfortunately, it's been such a long time ago, but that's what we should, that's the mystery, right?
If you invited
But it
someone,
doesn't seem consistent.
if you invited someone over your house after the bar and then they ended up dead on your lawn 6 hours later, would you expect the police to search your house?
Well, unfortunately, if that were the circumstance, regardless of who it was, I would believe that law enforcement would comb my house and potentially go to each neighbor and interview each neighbor, and more testimony from neighbors and other individuals would have been presented. I don't know if that was just dismissed because they didn't think it was relevant testimony by the defense nor the prosecution, but I think it would have been important to have interviews of the neighborhood or individuals, including a search of my house, because it's, even though it's my house, you know?
Yeah, no, it's funny you mentioned that, because across the street, and this was not even brought up at the trial, across the street, the deputy, or the lieutenant, I believe he's like a deputy chief now, named by the name of Tom Kelleher, from the Canton Police Department, lived directly across the street from the McAlberts at, I believe, 31 Fairview. And he has a Ring camera, and I actually knocked on his door one time as part of my investigative journalism. He didn't answer. And I stood where the Ring camera was, and I kind of pointed my camera out of the street, and lo and behold, it captures directly where this incident would have occurred if Kara Reed ran him over. If the defense had presented Tom Kelleher as a witness, and he had said that, you know, the police never asked for his Ring camera video, would you find that suspicious as a juror?
Of course. I mean, it would be also suspicious if there was no recording, or there was supposed to be a recording and then suddenly it got lost.
And that's happened a couple times too, I believe.
Correct, in the course of the court.
Yeah, and didn't you guys, what do you guys think of the inverted video that was shown in court? Did you think that was on purpose? Anybody think that was an accident?
It was definitely confusing because we all kind of thought it was on one side of the vehicle versus the other side. They were all on the right side versus the left side. And ultimately, when we realized it was inverted, it could be a honest mistake, but it's kind of hard to make an honest mistake when you have to work hard to invert a video, right? I think
that's enough of the juror interview for now. This interview goes on for another hour and 20 minutes. And no, I'm tapping out, people. I'm tapping out. I can't do any more. I can't do any more right now. I'm tapping out. Is there anything else? Has the court docket dropped anything today? Is there anything on the court docket? Can I yell at the judge some more? That'd be good. Yeah, you feel my pain? Yeah, big time. 100%. Don't blame me, big guy. Yeah. Yeah, I mean, some of the jury's ability to reason leaves a lot to be questioned. You know, actually, suddenly it crystallized. I just figured it out. Yeah, some of the jury's ability to reason is flawed. And so they can't understand what reasonable doubt is because they literally can't reason. That's it. They can't reason. So they don't understand what reasonable doubt is because they don't understand what reason is. That's it. That's the problem. How do I fix that? How do I make the reasonable man reasonable? That's a hat I need. Yeah. Make the reasonable man reasonable again. I'm going to get myself a red hat that says that. Make the reasonable man reasonable again. As in reasoned. As in reason. As in logic and thinking with the mind parts. Talk to the jury like they're fifth graders. I don't know, man. I think some fifth graders might be able to do better. I know some third graders who understand basic reasoning. I'll tell you what, man. You had it, Manhattan. It made it easier. Respect. Critical thinking was murdered a long time ago. Sadly true. Sadly, very true. People feel no reasoning. Yeah. What suggestions do I have looking for jurors? Like, what qualities would I be looking for? People with 2 brain cells to put together would be nice. Carol Newman became, thank you, Southern Mom. Carol Newman became an uncivilian. Forrest Dump gave $2. Duncan, Idaho gifted 10 gift memberships. Deborah Claire became an uncivilian. Forrest Dump said this jury needs Denzel from Philadelphia to help. Even Denzel, man. Even Denzel. Long Crime Briefs for $1. Long Crime Briefs gave $1.99. Forrest Dump, $2. But she had 9 drinks according to someone else, right? I don't know. Who cares? She didn't hit him. It doesn't matter. She could be as drunk as anyone. It wouldn't matter. Amy's positive pathways became an uncivilian. I could use some of those positive pathways. Can you send me a few? I feel like I'm running out right now. Miss Macy became an uncivilian. Anna Banana, CA, $5. Sui Generous, love your dives. Thank you very much. $5 said, could you tell us based on how you'd approach the case's defense, based on how jurors ultimately deliberated on the evidence? I can tell you this. Every defense lawyer is strongly well advised to take any comment from any particular jury with humongous, massive grains of salt. Okay? Every jury is a dynamic unto itself, and there is no guarantee, none, zero, zilch, that what one jury cared about will be what another jury cared about, or what one jury focused on, another jury will focus on. And there's evidence to prove that in jury interviews based on jurors. Like, what they focus on is part of the dynamic of the group. So I can tell you this. I would definitely not be changing what I'm going to do in any substantial way based on any particular juror interviews, even if I could interview all 12 of them. That information is tangential at best, because I've got a new group of 12. And there is zero guarantee this new group of 12 will care about anything that other group of 12 cared about. In fact, basically the only thing you can be sure of is that they'll care about different things. You don't know what they are, but they'll care about different things. So it is a mistake to overly tailor your defense based on any particular juror feedback or mock juror feedback. That is a mistake. You gotta just kind of do it all and hope for the best, man. It's a ride. It's a ride of uncertainty. Grab your ankles and hope for the best, baby. Duncan, Idaho gifted 5 gift memberships. Ron H became an uncivilian. Bella Brat for you gave $5. Say thank you for trying to make us smarter and to think through all this. The jurors seem to have thrown out ARCA. Yeah, Bella Brat for you gave $10. Exactly, Kurt. Exactly. A DUI charge might make sense with their statement. Thank you all for all you do. You're welcome. Captain Tripp says for $1.99 says can't trust anything a cop says. Fair. The Chugi Show Live for $4.99 says I'm at the beginning. The statement feels inopposite or inappropriate for him to be making. This is odd to me. I don't like it at all. Crystal Shivers became an uncivilian. Captain Trips for $1.99 said over 3 weeks. In terms of my weight loss, I presume. Yeah. Well, it's more like 2 months when you factor in the semi-glutide. But yeah, I'm down 42 pounds from peak, give or take. So things are going great for me. Only another 130 pounds to go. We're making progress. Orwellian person became an uncivilian. Pug and Spice became an uncivilian. I shot the clerk? Question mark, became an uncivilian. Yeah, 149.9 today. I was just under the 350 pound, 349.9. I was just under that 350 mark, and I was very thrilled. So yeah, so we're making progress, man. We're making progress. Drop the media motion, Canoni issue in Discord. We can cover it. That's fine. Oh, we read this one. We read the, we read the judge's order. I have no problem with that. My case, no, I'm not doing semaglutide. I'm doing Mounjaro. I originally was on semaglutide, but I had some side effects with it, principally nausea. So I didn't really like the semaglutide. So I've been on Mounjaro, which is trizipatide. I've been on that for, I was on compounded originally, and now I'm on name brand, which is very expensive. But I've been having a lot of success with it, so I'm going to stick with it despite the expense. Yeah, I'm a big boy. I weigh a lot more. I weigh a lot more than you think I would weigh. I tend to hide my weight pretty well for my weight. It's like people wouldn't think I was, people wouldn't think I was 390 pounds. People would think I was fat, but not 390 pounds fat. So yeah, I definitely hide my weight better than yeah. So it's like I'm definitely fat, but I'm not like 300. I don't look 390 pounds fat. I hide my body weight pretty well. So I got that going for me. How tall am I? 5'11 and a half, 6 foot on a good day. My BMI is about 48 right now. I'm a little bit less, maybe. I'd have to double check. I'm significantly overweight. For my body weight, I believe average is something like 185 or 190 pounds for 6 foot, 5'11 and a half, 6 foot. I think is 190. Right now I'm eyeing 220 is what I'm eyeing. Hopefully with some muscle mass on there. So that's what I'm eyeing right now, but yeah. Your goal is 120. That's pretty light. BMI is outdated. I understand that BMI has its problems, but that is not my case. Yeah, I understand that BMI can be misleading in some cases. That is not my situation, I assure you. Right? It's not because I'm just packing an extra 100 pounds of pure muscle. That is not my situation, I assure you. So while BMI might be misleading for many people, I feel like for me it's a more accurate assessment. So yeah. Do heavy squats? Well, I don't really have the facilities for that right now. And the last time I tried to do squats, like my body hated me. But it's not the worst idea, but yeah. All right, guys, I'm going to go ahead and sign off for now. I've enjoyed our time together. It's been fun. I've been on Civil Law. Till later, my friends. I hope all's well. Cheers for now, my friends, and goodbye.